Hi friends, my name is Amit Jyoti. I am an assistant professor at the O.P. Jindal Global University. This module is titled as Just Cogens and Human Rights. We'll discuss some conceptual issues. Let's begin by understanding what is the concept of just cogens. Just cogens is in fact a Latin term which means compelling law. It essentially means that it is such a preemptory rule of international law which overrides any rule or agreement that is in conflict with it. Such a norm, it is said, must be followed by all nations of the world, and its nature is such that no derogation is permitted from such a rule. The formal establishment of the concept of just cogens norms happened by way of Vienna Convention on the Law of Treaties of the year 1969. The now famous Article 53 of the Convention specifies that a treaty is void if at the time of its conclusion it conflicts with the preemptory norm of general international law. For the purposes of the present convention, a preemptory norm of general international law is a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted, and which can be modified only by a subsequent norm of general international law having the same character. This foregoing section provides the least amount of clarity on how exactly a just cogens norm is born. However, one thing that is clear is that it is a norm which is accepted and recognized by the international community of states as a whole. In this regard, however, it is also important to look at Article 66 of the Vienna Convention, which specifies that any one of the parties to a dispute concerning the application or the interpretation of Article 53 by a written application submitted to the International Court of Justice for a decision unless the parties by common consent agree to submit the dispute to arbitration. Therefore, it is the International Court of Justice that ultimately decides what a just cogens norm is and if there is a disagreement between states. This aspect assumes significance as states are willing to raise the status of an ordinary norm to the level of just cogens in order to support their contention in court. Here, critics are quick to point out that this is done for selfish reasons by the state. The fact of the matter is that by way of these submissions itself, the International Court of Justice gets the much needed opportunity to opine on the matter at least. Now, let's discuss just cogens and its hierarchy amongst sources of international human rights law. Now, under domestic law, there is a clear constitutional normative hierarchy that exists amongst the various legal norms that are to be followed. For example, in the Indian legal system, we have laws that are made by the Parliament, which are the supreme law of the land. Thereafter, we have judicial interpretations which further expand the scope and applicability of these laws. Of course, there are other sources of law that we need to look at in India, but the point we come across is that we know where to look and in what order to look them at. However, this is not true in the international arena, where there is no clear constitutional normative hierarchy. In fact, there is no one constitution that all the states abide by. In this situation, it becomes more and more complicated with the proliferation of multiple courts like the European Court of Human Rights, the International Court of Justice, the ICC amongst others, along with specialized agencies that deal with subject specific issues only. With so much to look at, the question becomes where to look first for an internationally binding norm. The answer to this question is not very simple. However, we look at the various just cogens norms on how they fare. Article 38, Clause 1 of the Statute of the International Court of Justice lays down the following sources of law that the ICJ is to look at before giving its decision. That is, international conventions, international custom, general principles of law that are recognized by civilized nations, and a subsidiary means, that is the judicial decisions and the teachings of the most highly qualified publicists of various nations. Now, from this list as provided in the ICJ statute, it is very clear that the drafters of the statute did in fact contemplate some hierarchy amongst the sources that are listed in this article. On similar lines, Article 53 of the Vienna Convention on the Law of Treaties 1969 provides that a treaty would be void if at the time of its conclusion it conflicts with a preemptory norm of general international law. Further, Article 64 of the Vienna Convention lays down that if a new preemptory norm of general international law emerges, any existing treaty which is in conflict with that norm becomes void and hence terminates. Now, having a cumulative look at these provisions of the ICJ statute and the Vienna Convention, it wouldn't be wrong to say that there is a certain level of normative hierarchy within international law. This is especially in light of Article 103 of the UN Charter, which says, in the event of conflict between the obligations of the members of the United Nations under the present Charter and their obligations under any other international agreement, their obligations under the present Charter shall prevail. Now, given this, along with Article 64 of the Vienna Convention of the Law of Treaties, it wouldn't be wrong to point out that just cogens norms sit right at the top of the ladder amongst sources of international human rights law. Moreover, given the fact that these norms defeat the provisions of any conflicting pre-existing treaty, it also wouldn't be wrong to point out that in context of human rights, just cogens tends to play a very important role. Here, the question also arises of the fate of just cogens norms in case of conflict between UN Charter obligations, Security Council resolutions, and the just cogens norms. The argument has been summed up beautifully by Mr. Zinovi in his research paper, which is titled as Human Rights Enforcement via Preemptory Norms, a Challenge to State Sovereignty. Here he states, and I quote, in author's view, in the case of conflict between UN Charter obligations or the Security Council decisions and just cogens norms, the latter should prevail over the very essence of their normative capacity. These are the values that the international community recognized as non-derogable, and no treaty as stipulated in the Vienna Convention reflecting customary law can be superior to them. The UN Charter is formally a multilateral treaty, the expression of the will of the signatory states. On the one hand, the UN Charter, due to its extraordinary significance, is one of the treaties in which preemptory norms can be identified. On the other hand, if just cogens is a reflection of existing law, a form of customary law that existed in the international legal order, it is clear that the United Nations Charter and its interpretation necessarily need to correspond to these norms. Just cogens is a dynamic, changeable concept, evidence of the legal and political status quo of the international community. International law itself changes constantly and rapidly. That is a reason more to acknowledge the primacy of just cogens, especially when it comes to their applicability. Now, let us look at the legal effects of just cogens. Just cogens sits right at the top of the ladder when it comes to hierarchy of rules in international normative order. Now, because of this, the most conspicuous consequence of this higher rank is that the principle at issue cannot be derogated from by the states through international treaties or local or special customs or even general customary rules not endowed with the same normative force. The just cogens nature of the prohibition implies that such prohibition has attained the level of a fundamental standard of the international community as a whole. Now, at the interstate level, this principle serves to internationally delegitimize any legislative, administrative or judicial act authorizing any act going against this fundamentally recognized principle. This implies that if a state were to authorize measures, let us take for example torture, then such measures would not be accorded international legal recognition. And in fact, proceedings could be initiated by people having the requisite locus standi to declare the said measures as void ab initio. What is even more important is that perpetrators of such measures may nevertheless be held criminally responsible for torture, whether in a foreign state or in their own state under a subsequent regime. As the International Military Tribunal at Nuremberg put it, individuals have international duties which transcend the national obligations of obedience imposed by the individual state. In other words, this principle directly limits the sovereignty of states to enter into contractual relations which might be detrimental to human rights which are recognized as just cogens. At the individual level, the effect is that every state becomes entitled to investigate, prosecute and punish or extradite individuals accused of torture who are present in a territory under its jurisdiction. Other consequences appear to be that such measures which go against the fundamentally recognized principles may not be covered by the statute of limitations, and in fact must note to be excluded from extradition under any political offence exemption. To conclude, in the words of Inter-American Commission on Human Rights, it says, norms of just cogens derive their status from fundamental values held by the international community as violations of such preemptory norms are considered to shock the conscience of humankind and therefore bind the international community as a whole, irrespective of protest, recognition or acquiescence. Hence, the foregoing legal effects that we have just discussed. Now, let us look at human rights norms as just cogens versus the concept of state sovereignty. States enter into treaties and agreements with other states on a voluntary basis. Only when they consent to the substance in the treaties, they become signatories to such treaties. Now, jus cogens aims right at the heart of the state consent, as states are bound by this fundamental norm even if the states do not agree to it. Accordingly, the discussion of whether or not jus cogens norms actually trump state sovereignty is a lengthy one. In fact, scholars are fully divided on this one issue. On one hand, we have scholars who argue that jus cogens is a norm that trumps all defenses including state sovereignty. Whereas, there are others who argue that jus cogens does not trump state sovereignty. Given that no one answer has been reached in this debate, it is important to specially consider arguments of scholars who argue in favor of state sovereignty. Given how jus cogens has been articulated in Article 53 and 64 of the Vienna Convention of the Law of Treaties, it seems difficult to believe that it wouldn't be able to trump every other rule of international law. Having said that, let us now discuss some of the arguments that are put forth by the supporters of this contention. The first being, jus cogens rule prohibits a certain conduct. The same rule does not bar states from relying on state immunity before national courts. Second, denial of state sovereignty could result in judicial chaos as states would potentially be subject to a very large number of claims. Third, such trials could take place before the courts of states not inclined to decide fairly with regard to the defendant state. For example, Iran sits in judgment over the alleged war crimes committed by Israel or Pakistan. Or let's say Pakistan sits in judgment over the alleged atrocities committed by India in the Jammu and Kashmir, enforcing their notion of jus cogens. To the first point, it could possibly be argued that every substantive jus cogens norm must be reasonably presumed to contain an enforceability element to it as well, so that the defense of state sovereignty must be limited to a certain extent to pave way for its implementation. Moreover, existence of jus cogens norms without giving it to the requisite teeth for its enforcement raises doubts which hit the core of the whole concept. Now, to the second and the third points dealing with judicial chaos, it could possibly be argued that every basis of jus cogens norms is the acceptance and recognition by the international community of states as a whole of the said norm. Therefore, no state may unilaterally declare that a certain rule forms part of its fundamental principle and apply its own rules to ridicule the defendant state's interest. Moreover, judgments based on such a subjective and false understanding of jus cogens would not be enforceable in any other state of the world. In addition, lifting of this veil of state sovereignty could possibly also act as an incentive, a deterrent for states to comply with the most fundamental principle of society, especially in order to avoid public shaming in national and international courts. With respect to human rights norms, however, it is important to note that on June 25, 1993, representatives of 171 states adopted by consensus the Vienna Declaration and Program of Action of the World Conference on Human Rights after presenting to the international community a common plan for the strengthening of human rights work around the world. Now, the Vienna Declaration and Programme of Action marks the culmination of a long process of review and debate over the current status of human rights machinery in the world. It also marks the beginning of a renewed effort to strengthen and further implement the body of human rights instruments that have been painstakingly constructed on the foundation of the Universal Declaration of Human Rights since the year 1948. Paragraphs 4 and 5 of this declaration are of utmost importance for the purposes of our discussion. These paras read as: the promotion and protection of all human rights and fundamental freedoms must be considered as a priority objective of the United Nations in accordance with its purposes and principles. In particular, the purpose of international cooperation. In the framework of these purposes and principles, the promotion and protection of all human rights is a legitimate concern of the international community. The organs and specialized agencies related to human rights should therefore further enhance the coordination of their activities based on the consistent and objective application of international human rights instruments. All human rights are universal, indivisible, and interdependent and interrelated. The international community must treat human rights globally in a fair and equal manner, on the same footing and with the same emphasis. While the significance of national and region particularities and various historical, cultural and religious backgrounds must be borne in mind, it is the duty of states, regardless of their political, economic and cultural systems, to promote and protect all human rights and fundamental freedoms. Now, even though the legal character of this declaration is non-binding, its importance in how it emphasizes the understanding of human rights on a global platform cannot be easily ignored. This declaration, in fact, can be seen as laying proper emphasis on developing effective international cooperation for the realization of purposes set forth in the Universal Declaration of Human Rights of 1948. This shift can also be looked at suggesting a more agreeable approach by the international community of states, specially and solely vis-a-vis human rights norm. This change was also reflected in the Barcelona traction case between Belgium and Spain, where the Belgian government sought reparation for damage claimed to have been caused to Belgian nationals, shareholders in the Canadian Barcelona Traction Company by the conduct of various organs of the Spanish state. One of the preliminary arguments of the Spanish government was to challenge the capacity of the Belgian government to bring the said suit to the International Court of Justice, which the judges declined to. In this regard, it has been observed by Mr. Zinovi in his research paper, which is titled as Human Rights Enforcement via Preemptory Norms, a Challenge to State Sovereignty, which we previously quoted as well. He says, the change in international legal values was also reflected in the case law of the International Court of Justice even before the end of the Cold War. Regarding locus standi of a state before the court in matters considering jus cogens, the Barcelona traction case was the cornerstone of the recognition that jus cogens norms give to the legal interest of any state to start the proceedings. Although a procedural aspect, it might have significant consequences regarding the different level of human rights record amongst the state. If we look at judicial decisions versus the concept of jus cogens and state sovereignty. International judges also appear to be somewhat divided in their opinion. Though majority of the opinion favor state immunity, there are those minority of judges who feel the rule should be otherwise. Let us discuss what these courts have held so far. First, the European Court of Human Rights has not accepted the proposition that states are no longer entitled to immunity in cases regarding serious violations of international humanitarian law or human rights law. In 2001, in Al-Adasani versus United Kingdom, the European Court concluded stating, notwithstanding the special character of the prohibition of torture in international law, the court is unable to discern in the international instruments, judicial authorities or materials before it any firm basis for concluding that as a matter of international law, a state no longer enjoys immunity from civil suit in the courts of another state where the acts of torture are alleged. In the following year, once again in another case, the European Court of Human Rights once again, while upholding the state immunity argument, stated that the court does not find it established, however, that there is yet acceptance in international law of the proposition that states are not entitled to immunity in respect of civil claims for damages brought against them in another state for crimes against humanity. Now, looking at the International Court of Justice, it has also had the opportunity to extensively give opinion on this issue in the case of Germany versus Italy. Here, the court concluded stating that under customary international law, as it presently stands, a state is not deprived of immunity by reason of the fact that it is accused of serious violations of international human rights or the international law of armed conflict. In the opinion of the court, no such conflict exists. The two set of rules address different matters. The rules of state immunity are procedural in character and are confined to determining whether or not the courts of one state may exercise jurisdiction in respect of another state. They do not bear upon the question whether or not the conduct in respect of which the proceedings are brought was lawful or unlawful. For the same reason, recognizing the immunity of a foreign state in accordance with the customary international law does not amount to recognizing as lawful a situation created by the breach of a jus cogens rule. Having now talked of the judgment overall, it is also important to look at the strong dissenting opinion that was given in this case by Justice Trinidad. In his opinion, which was dissenting, he noted, "One cannot embark on a wrongfully assumed and formless lack of conflict between procedural and substantive rules, depriving jus cogens of its legal effects and consequences. The fact remains that a conflict does exist, and the primacy of jus cogens, which resists to and survives such groundless attempt at its deconstruction. There can be no prerogative or privilege of state immunity in cases of international crimes such as massacres of civilian population and deportation of civilians and prisoners of war to subjection to slave labor. These are grave breaches of absolute prohibition of jus cogens for which there can be no immunities. Jus cogens stands above the prerogative or privilege of state immunity, with all the consequences that ensue therefrom, thus avoiding denial of justice and impunity. On the basis of all the aforesaid, my firm position is that there is no state immunity for international crimes, for grave violations of human rights and of international humanitarian law. In my understanding, this is what the International Court of Justice should have decided in the present judgment. To conclude, he said, it must be said that the debate between jus cogens norms and state sovereignty still lingers. However, the position legally seems to be clear as of now and tilts against the concept of jus cogens. Thank you for listening to this module.